Hi there, Scott Peterson from DeRazio Peterson with another episode of the New York Injury Law Show. The object of the show is to help provide you with information, help guide you down the path that you're dealing with after having experienced a traumatic injury or malpractice or an injury to you or a family member in New York. We're here to help answer your questions and help make this process easier for you. Today we're talking about mediation. What is it? Should you do it? Is it worthwhile? You may have heard the term before, but mediation is essentially a process by which parties opposing one another, typically in a legal proceeding but not always, sit down with a neutral third party and try to work out their dispute. They sit down in a room, typically a law office or some type of a conference room, and they sit down as long as possible or as long as necessary and try to hash out some kind of an agreement that avoids the unpredictability of going to trial. Sometimes that's good. Sometimes it's the appropriate strategy in a case. Other times it's not. There are situations where cases need to go to trial for various reasons. There are situations where mediation is not the best approach for settlement negotiations on behalf of an injured person. We do take cases to mediation with some regularity. And the reason for that is because of what I said before. It's the unpredictability. It removes unpredictability from the plaintiff's perspective if you are able to resolve a case short of trial. When I say unpredictability, I mean juries are unpredictable. One jury hearing a set of facts could find one way, another jury hearing the same set of facts could find another way. So our philosophy with our clients is if we can obtain what we think is a good settlement, it's worth considering. And one way to do that is approaching the settlement negotiation through mediation. So the typical mediation involves the parties coming together and hiring a mediator. Mediators are often trained. Sometimes they're not. Sometimes they're former judges, former Court of Appeals judges, or judges who have been involved in lots of settlement negotiations throughout the course of their careers. This can be really helpful because these judges have seen a lot of cases. They have a lot of experience in determining strengths, weaknesses, valuation, and a good, effective mediator is able to push the parties closer together and a bit outside of their comfort zone often in order to try to get the case resolved. The upside of mediation is that it's not binding. So you're able to go there and explore the possibility of settlement without having to worry about the fact that you can't walk away. There's always the option of walking away from mediation if it's not successful, if you feel that the other side is being disingenuous or is not putting their best foot forward to try to settle the case, which does often happen. And so from the client's perspective, the plaintiff's perspective, there's not a whole lot of downside to attending a mediation. Mediation is typically considered confidential, so any negotiations that happen in that context typically can't be used against the individual if the case goes to trial. So in some circumstances, we think mediation is a good approach, provides a benefit to a client or an injured person in the state of New York, and can lead to good settlements, and often does. So hopefully this clears that up for you. If you have other questions, feel free to reach out to us. We're happy to help. This is what we do. And feel free to reach out to us or give us a call.